These restatements, such as the restatement second of contracts and the restatement second of torts, serve a similar function to the codes that are thought to be characteristic of the civil law countries. Comparative law scholars vigorously debate whether the differences between civil and common law are more apparent than real. Besides the difference in history between common and civil law, the laws are applied differently in the two traditions. In the common law countries, the arguments for the two sides in a dispute are made exclusively by their lawyers, and the judge is not supposed to direct a line of questioning or develop an argument. In this adversarial process, the judge acts more or less as a neutral referee who makes the lawyers follow the rules of procedure and evidence. The principle underlying the adversarial system is that the truth will emerge from a vigorous debate by the two sides. In contrast, the civil law judge takes an active role in directing questions and developing arguments. In this inquisitorial process, the judge is supposed to ferret out the truth. The lawyers often have to respond to the judge rather than develop the case themselves. The principle underlying the inquisitorial system is that the court has a direct interest in finding the truth regarding private disputes and crimes. Another difference between the two systems concerns the use of juries. Juries are more commonly used in common law systems. In America, either party to a dispute usually has the right to a jury trial, although both parties sometimes waive this right and allow the judge to decide the case. In England, the jury has been abolished in almost all civil trials since 1966, but it is often used in criminal trials. Superscript 2, which reads, except in cases involving defamation. Returning to the text. Notice the different use of civil in the preceding sentence. Superscript 3, which reads, civil law has two meanings. It may refer to the system of law in most of continental Europe that rejects common law. In addition, civil law may refer to laws controlling disagreements between two private parties, which might arise, say, from a broken contract or an automobile accident. In this latter sense, the opposite of civil law is criminal or penal law, in which actions are initiated by the state's prosecutor against someone accused of violating a criminal statute, such as forgery or murder. Thus, the common law of, say, contracts can be described as civil law, meaning private law, or not criminal law. Returning to the text. In France, however, the jury has been abolished for all trials except the most serious crimes, like murder. In general, the abolition of juries is more advanced in continental Europe than in some common law countries. In a common law trial before a jury, the judge is supposed to decide questions of law, whereas the jury is supposed to decide questions of fact.